All right, so today we're taking a deep dive into UK contract law,
Yeah,
specifically how contracts actually end.
right.
I'm sure you've had to deal with contracts at some point, whether it's, you know, like a big purchase or a work agreement, or even just, blindly clicking agree to those terms and
Yeah,
conditions.
yeah, we all do that.
But have you ever stopped to think about what happens when things go wrong?
Yeah,
Or even how a contract formally comes to an end?
right.
It's not always as simple as you might think.
It's not, no.
So our deep dive today is going to unpack all of that
Okay.
using, some really interesting legal analysis on UK contract law.
The thing is, we get so caught up in the beginning of an agreement that we forget to think about how it wraps up and how it ends.
Exactly. And
Right.
there's some surprising ways a contract can end beyond the obvious, we completed the job.
Right.
Or,
Yeah.
it just naturally ended.
Yeah. And UK law actually lays out 4 clear ways that a contract can end:
Okay.
expiration, termination, vitiation, and frustration.
Oh.
So we can go through those.
All right. Let's break those down.
Let's start with expiration,
What?
the most simple one.
Yeah.
This is where a contract just runs its course.
Okay.
Reaches a natural end.
So that's like, your gym membership expires after a year.
Yeah.
Or a lease ends on a specific date.
Exactly.
As expected.
Built in, there are fixed dates,
Right.
termination clauses that allow either party to walk away
Yeah.
after a certain period, or if specific conditions are met.
Okay. But then we get to termination.
Yeah.
And this is where things get a little bit more spicy.
Absolutely.
Right.
Termination is all about ending a contract before its natural expiry date.
Okay.
And that can happen for a number of reasons.
Yeah.
The most common one is breach of contract.
When I hear breach of contract,
Right.
I just think about like lawyers in a courtroom yelling at each other. But it's not always that dramatic, is it?
No, not at all.
Okay, so
in simple terms, a breach just means that one party didn't hold up their end of the bargain.
okay.
And it can be as simple as failing to deliver goods on time
Okay.
or providing a service that doesn't meet the agreed standards.
So if I order like a custom-made cake
Yeah,
for a party and the baker delivers a plain one instead,
exactly.
that would be a breach.
That would be a case of what we call defective performance.
Right.
They did something,
Right.
but it wasn't what was promised in the contract.
Yeah, I remember reading a funny example
Yeah.
in one of the sources. They compared it to, ordering beans and getting peas instead.
Yeah, actually,
And,
it highlights the point perfectly.
Something arrived,
Right.
but it's not what you bargained for.
Yeah.
And depending on the severity of that performance,
Yeah.
the remedies
Yeah.
can vary quite a bit.
Right. Right.
What about those situations where someone makes it impossible to even fulfill the contract?
Yeah.
That seems a little bit more serious.
That's what we call incapacitation,
Okay.
where they make it impossible
Okay.
to honor their side of the agreement.
So,
Imagine you agree to buy a rare antique from a dealer,
uh-huh.
but then they go and sell it to someone else
Right.
before you can complete the purchase.
Before you can get your hands on it,
Yeah.
you're just stuck with nothing.
What happens then?
The non-breaching party has options.
Okay.
They can try and hold the breaching party
Yeah.
to the original agreement,
Uh-huh.
potentially through legal means,
Okay.
or they can choose to just cut their losses,
And say, see you later.
terminate the contract entirely.
So basically saying like, okay, you broke your promise.
Yeah,
I'm out of here.
exactly.
But can you just casually say that?
Well, no.
Or does it have to be super official?
Termination for breach has to be done in a very clear
Okay.
and unambiguous way.
You can't just sort of hink at it
Yeah.
and then change your mind.
Right.
The law needs that clarity to
Right.
protect everyone involved.
Yeah, but what's interesting
Yeah.
is that even if you decide to sue over a breach, it doesn't always mean the contract is over.
That's a really good point.
Right.
Yeah.
Sometimes the non-breaching party isn't looking to just completely end the agreement,
Yeah.
right? They might just be suing for like
Yeah.
damages to compensate for the loss.
They may still want it to continue.
Yeah.
Yeah.
Okay, so we've got expiration,
Right.
we've got termination,
Yep.
and then there's this word that really threw me for a loop,
Right.
vitiation.
Vitiation.
What in the world does that even mean?
Well, don't worry. It's just a fancy legal term.
Okay.
But in essence, it means that the contact was flawed from the very beginning.
Okay.
Almost like the foundation was shaky and the whole thing needs to be re-examined.
This is not about something that happens during the contract. It's about a problem that existed when it started.
Exactly.
Okay.
And there are two main scenarios where vitiation comes into play.
Okay.
Misrepresentation and mistake.
Okay, now misrepresentation sounds a bit like straight up lying to me.
Yeah, it is. Yeah.
To trick someone into a contract.
Yeah.
Right.
You think about selling a used car
Right.
and claiming it's never been in an accident when you know it has.
Yeah, that's the classic
Used car salesman.
used car salesman trick.
But how does the law distinguish between a lie and an honest mistake?
Yeah, well, that's where things get nuanced.
Okay.
Misrepresentation can be fraudulent,
Okay.
meaning it was a deliberate lie.
Okay.
Negligent, meaning they were careless with the truth.
Okay.
Or even innocent, where they genuinely believed the false statement was true.
So what happens if you've been tricked into a contract?
Okay.
Through misrepresentation, can you just rip it up
Well,
and walk away?
it depends on the type of misrepresentation
Okay.
and the specifics of the situation.
Okay. But in some cases, you might be able to get out of the deal through a process called rescission.
Now, rescission, that sounds like
It basically means undoing the contract.
a medical term.
Yeah.
Like
Putting everyone back where they started,
you're cutting something out.
as if the agreement never happened.
So you're hitting rewind
Exactly.
on the whole deal.
In other cases, you might be entitled to damages to compensate for any losses
Okay.
you suffered.
So really, it just depends on the situation.
Yeah.
Okay, now the other scenario that you mentioned under vitiation was mistake.
Right.
That seems pretty broad.
Yeah.
Can any old mistake void a contract?
Well, not quite.
Right.
In contract law, a mistake
Yeah.
refers to a situation where both parties were genuinely mistaken
Okay.
about a key fact
Yeah.
that formed the basis of their agreement.
So it has to be a pretty big mistake.
And it has to be pretty significant,
Okay.
not just a minor detail.
One of the sources had this hilarious example of like, imagine buying something that you already own,
Exactly.
right? Like
Yeah.
the contract's pointless
It would be pointless.
because
Yeah.
you already own it.
The fundamental purpose of the agreement is flawed.
So in those situations, the contract might be deemed void,
Yes.
meaning it never even
Well,
existed.
it legally existed in the first place.
Okay,
Yeah.
so we've tackled expiration,
Yeah.
termination,
Yeah.
and vitiation.
Yep.
One more left,
For more
frustration.
frustration.
Frustration is where something unforeseen happens
Okay.
after the contract is
That's
signed,
fair.
making it either impossible to fulfill the agreement
Okay.
or radically changing its original purpose.
Okay, so like if I agreed to cater a wedding
Right.
and then the venue burns down
Yeah.
the week before,
Yeah.
that would make it pretty difficult to fulfill my obligation.
That's a good example. But
Yeah.
remember, it can't just be
Yeah.
any sort of minor inconvenience.
Yeah.
It has to be something significant
Okay.
and truly disruptive.
Okay.
Something neither party could have reasonably
Anticipated.
or controlled.
Okay.
The classic example involves a ship and a war,
Okay.
where there's a contract for a ship to deliver goods to a specific port.
Uh-huh.
If war breaks out and that port becomes enemy territory,
Right.
you can't get there.
Yeah.
It becomes impossible
But legal.
or illegal
Yeah.
to fulfill the contract.
So that's pretty dramatic,
Yeah.
right? It really highlights how
Yeah.
external factors can just completely derail a contract
Yeah.
through no fault of either party.
Right.
It's important to emphasize
Yeah.
that frustration can't be used as just a loophole
Right.
to get out of a bad deal.
Yeah.
It has
But
to genuinely...
It has to genuinely make the contract
Yeah.
impossible to perform.
You can't just be like, oh, I don't want to do it anymore.
Yeah, you have buyer's remorse.
Yeah.
You can't just get out.
Okay.
It's not a get out of jail free card. So the courts take that pretty seriously.
They do, yeah.
Okay, now
Yeah.
you mentioned anticipatory breach earlier.
Right.
What exactly is that?
Anticipatory breach is a situation where one party hasn't technically breached the contract yet,
Okay.
but it's become crystal clear that they're going to.
Okay.
So imagine you've hired a band for your event,
Yeah.
but a week before they announce they've broken up,
Oh, no.
they're canceling all future gigs.
Oh.
They haven't breached the contract yet
Okay.
because the event hasn't happened,
Right.
but it's pretty obvious they won't be able to fulfill their obligation.
So you can see the train wreck coming,
Exactly.
but you haven't been officially let down yet.
That's right.
And anticipatory breach
Yeah.
can manifest in a couple of ways.
In a couple of ways, yeah.
What would that say?
Repudiation,
Repudiation.
which is a straight up refusal to perform.
Okay.
Like, I'm not going to do what I promised.
Right.
And then there's disablement. which involves doing something that makes it impossible to fulfill the contract
Right.
before the deadline.
Like if that band sold all their instruments
Exactly.
and moved to a remote island
That's a good one.
with no internet access,
Yeah.
they haven't failed to show up for your event yet,
Yeah.
but they've made it pretty much impossible to do so.
And the interesting thing about anticipatory breach is that the non-breaching party has options
Okay.
even before the actual breach occurs.
Okay.
They can either choose to just hold on to the contract
Okay.
and try and enforce it
Uh-huh.
when the time comes,
Right.
or they can just accept
Okay.
the anticipatory breach and terminate it right away.
And so
Yeah.
that adds like a whole new layer of
Yeah.
strategy to the game.
Yeah.
It's like playing chess.
Yeah.
You got to think
Really
about
take ahead.
what your opponent's going to do.
Yeah.
But before we get too lost in the strategy of it all,
Right.
let's move on to something a little more concrete.
Right.
What happens when a contract does actually go wrong
Yeah.
and someone suffers a loss?
That's right.
What are their options?
Well, that's where the concepts of damages and remedies
Okay.
come into play.
All right.
The law provides a way
Okay.
to compensate that injured party,
Okay.
and in some cases, even to try and put things right.
Okay.
But that's a whole
Well, I'll
other
save that for next time.
deep dive for another time.
Okay. Welcome back.
Glad to be back. So last time we were talking about what happens when a contract goes wrong
Right.
and someone has to deal with that fallout.
Exactly. And that brings us to
Yeah.
the often confusing world of damages.
Yeah.
And remedies.
Damages and remedies.
Yeah.
Okay, so we're getting a little bit less theoretical here.
A little bit less theoretical. It's where things can get a bit more.
Real.
Yeah.
Right? Because now we're talking about like
Yeah.
real consequences.
Real consequences. Yeah.
Where, you know,
Someone was wronged in some way.
Yeah.
Or they suffered a loss
right.
because the contract wasn't fulfilled.
The whole point of damages is to compensate
Right.
that injured party
Okay.
for their loss.
So it's not about punishing.
It's not about punishing the other side.
Right.
It's about
making things right.
trying to restore the balance as much as possible.
Right. So the goal isn't to like bankrupt the other party.
Right.
It's to,
It's to put them back in the position
Yeah.
they would have been in.
if the contract
Yeah.
had just gone through as planned.
You had been performed as originally agreed.
Right. And it's
Of
not
course.
always
It's not a
a
perfect
perfect science.
science.
Especially when you think about like,
Yeah.
lost profits or future opportunities. That gets pretty complicated.
Yeah, you're right. Calculating damages can get quite
Yeah.
complex.
So is there a magic formula?
There's no magic formula.
Okay.
It's about looking at the contract itself,
Right.
the nature of the breach,
Yeah.
the impact it's had
Okay.
on the injured party.
So it's about like looking at the unique situation.
Exactly.
Okay.
But there are some guiding principles
Okay.
that courts use to try and ensure fairness.
Okay.
One key principle is
Yeah.
the duty to mitigate.
Now, mitigate sounds like something to do with a natural disaster.
Exactly. What does that even mean?
In essence, it means that the injured party
Okay.
can't just sit back
Great.
and watch the damages pile up.
Oh,
They have to take reasonable steps
Okay.
to minimize their loss.
So if a supplier backs out of a deal
Right.
to provide essential materials,
Yeah,
the buyer can't just sit around and do nothing.
exactly.
They got to find someone else.
They've got to explore other options
Right.
to try and keep the project moving forward
Yeah.
as best as they can.
Yeah.
That way the damages are limited
Yeah.
to the actual difference in cost
Right.
rather than just snowballing.
Into a much bigger problem, into something much larger.
Yeah.
Yeah.
What about those situations
Okay.
where the breach is just something that you can't really measure in, pounds and pence?
Yeah.
Like damage to reputation.
You hit on one of
How about
the
income, goodwill?
trickiest areas of contract law.
Yeah.
How do you quantify harm that's not
Right.
strictly financial?
Yeah.
How do you put a price tag on that?
Yeah.
It's not always easy.
Okay.
The courts have to really grapple
Yeah.
with these intangible losses.
Okay.
In some cases, they might award what's
Yeah.
called nominal damages.
Nominal damages sounds almost
It's a very small sum.
insignificant. Like,
It's mainly symbolic,
yeah, like a
but it acknowledges that a breach did occur.
consolation prize or something.
Kind of, yeah.
Okay.
But the financial loss is either too difficult to prove
Right.
or minimal.
So it's basically like,
Yeah.
okay, you were wronged,
Yeah.
but
The law recognizes you've been wrong.
we can't really put a number on that.
Yeah.
But sometimes
But sometimes
even financial compensation doesn't
Yeah.
really fix the problem.
isn't enough
Right.
to truly remedy the situation.
Yeah, that's where those equitable
That's
remedies,
where equitable remedies come into play.
legal superpowers,
Yeah.
specific performance,
Specific performance
injunctions. Oh, okay.
These are tools.
Remind me what those are.
Yeah, think of them as tools that the court can use
Okay.
when money alone won't do the trick.
Okay.
So specific performance
Yeah.
is a court order requiring the breaching party to actually fulfill their obligations under the contract.
So it's like make it so.
It's not always that dramatic,
But it's like, you have to do this.
but you get the idea.
The court's telling you, you have to do this.
But specific performance isn't granted lightly.
Okay.
Courts have to consider whether it's feasible
Right.
to enforce such an order
Okay.
and whether it's fair to both parties involved.
So it's not like a magic wand that you can wave.
It's not a magic wand, no.
It'd be like, you have to do this now.
Right.
Okay.
It's more of a carefully considered
Okay, so
order.
if you had a contract
Yeah.
with a world-famous artist
Right.
to create a one-of-a-kind sculpture,
Yeah.
and they backed out,
Right.
money can't really
Money couldn't replace that.
buy it.
That specific piece of art.
Right, so that's where specific performance might
Yeah.
come in. Okay.
Imagine a contract to buy a piece of land
Ah,
that has a particular historical significance
Right.
to the buyer.
yeah.
Financial compensation wouldn't really
Yeah.
make up for that.
Okay, and what about injunctions?
So
I mean,
injunction,
it's a little bit more
yeah, you could say that
restrictive.
restrictive.
Right.
An injunction is a court order
Yeah.
that essentially prohibits a party
Okay.
from doing something specific.
Okay.
So in the context of contracts,
Yeah.
it's often used to prevent a party from breaching the agreement
Okay.
in the first place.
If my neighbor signed a contract
Yeah,
promising not to block my view
yeah.
and then starts building a giant tower,
You could potentially seek an injunction
next door I could get an
to
injunction.
stop them.
Okay.
Or let's say you had a non-compete
Yeah.
agreement with a former employee
Yeah.
and they start working for a competitor.
Right.
You might seek an injunction to enforce that non-compete clause,
Okay.
protect your business interests.
So this is all starting to make sense.
Good.
But it does feel like you would need a law degree
Yeah.
to understand all of this.
It can feel overwhelming at
Yeah.
first glance.
Yeah.
That's why it's always a good idea to talk to a legal professional
Right.
if you have a significant contract
Right.
or a dispute.
But even having like a basic understanding
Yeah.
of these principles can be really helpful.
Absolutely, it can empower you to enter agreements
Yeah.
with more confidence.
Knowledge is power. Right.
Yeah.
Yeah. You mentioned earlier that courts consider
Right.
whether a particular remedy
Yes.
is just and equitable.
That's a great question.
What does that actually mean?
It highlights a crucial aspect of contract law.
Okay.
It's not just about rigidly applying rules.
Okay.
It's about achieving
Yeah.
a fair outcome,
Great.
considering all the circumstances.
So there's a human element.
There's a human element to it.
Okay.
It's recognizing that sometimes
Yeah.
a purely legalistic approach
Right.
might not lead to
The most just result.
the most just result.
So courts have a bit of...
They have a certain degree of discretion
Okay.
in applying these principles
Okay.
and remedies.
Okay.
So they might look at things like,
Yeah.
what was the intent of the parties?
Uh-huh.
Was there any bad faith involved?
Yeah.
Would a particular remedy create undue hardship
Right.
for one side?
So it's all about finding like a balance
Yeah, it's about finding a balance.
between upholding the contract,
Yeah.
but also making sure the result is fair.
And achieving a result that feels fair and reasonable
Okay.
to everyone.
But doesn't that create like a lot of uncertainty?
It's true that there's always
But how do you know
some level of uncertainty
what a court will decide?
when it comes to legal matters.
It's just that it's so subjective.
That's where
Yeah.
legal precedent and case law
Okay.
become really important.
So you can look at similar cases.
Exactly. By
Yeah,
studying
right there.
how courts have ruled
Yeah.
in similar cases.
Okay.
Lawyers can get a pretty good sense of
Yeah.
how a judge might approach a situation.
Okay.
It helps to create a framework
So it's like a
for decision making.
big legal puzzle
Yeah, you could say that.
that's constantly getting reshuffled.
And that's part of what makes contract law so fascinating.
We've covered
It's constantly
adapting
Yeah.
from
to new situations, business practices, societal norms.
what a contract even is.
Yeah.
So like all these different ways it can end.
Yeah.
What happens when it goes wrong?
It feels like we've climbed Mount Contract Law,
Yeah.
and we're standing at the summit taking in this breathtaking view. But you know what they say?
We've probably overwhelmed our listeners
The more you learn,
with all this legal stuff.
the more you realize how much more there is to learn.
Maybe we should take a break here.
Okay.
Give them the chance to digest all this
Let's give everyone a chance to digest
legal brilliance
all this legal brilliance
before we hit them with the grand finale.
We hit them with the grand finale.
All right, welcome back, everyone, for the final part of our deep dive into UK contract law.
Right.
So we've covered how contracts end, what happens when things go wrong.
Yeah.
But when you think about it, you know, understanding these legal principles isn't just about...
It's not just about...
avoiding lawsuits or winning court battles.
Yeah. It's about...
It's more about equipping yourself with the knowledge you need to...
Exactly.
...navigate agreements confidently.
Yeah. To know your rights and responsibilities.
Yeah, like, it's almost like having a secret decoder ring.
Exactly.
From the legal world.
Exactly.
You know, you might not need to understand every single clause or every little detail.
Right.
But knowing you have that ability can be really helpful.
And one of the most valuable tools is this concept of anticipatory breach.
Oh, yeah. Anticipatory breach.
Yeah.
That whole seeing the writing on the wall thing.
Yeah.
That's so relevant, you know, in business.
Absolutely. It allows you...
personal relationships.
To be proactive.
Even just everyday life.
Rather than reactive.
Yeah, it's like having a legal early warning system.
Exactly.
You can start figuring things out.
If you see those warning signs that the other party isn't going to fulfill their obligations, you can start...
before things blow up.
Taking steps to protect yourself.
It's been so eye-opening for me. I never realized how much, you know, strategy and nuance goes into just a simple contract.
Only just scratched the surface.
Right.
Contract law is a vast and ever-evolving field.
Yeah, this is really just like a launch pad.
Exactly. It's given us the basic tools
for further exploration.
The knowledge to navigate this complex legal landscape.
So what's the most important takeaway from all of this?
I think the most important takeaway from our exploration of UK contract law is that contracts are more than just pieces of paper. They're dynamic agreements.
Okay.
They require communication, consideration, a solid understanding of your rights and obligations.
What's like the one thing you want listeners to walk away with?
One key piece of wisdom.
Yeah, the big aha moment.
I think it's crucial to remember that even the absence of a formal written contract doesn't always mean you're off the hook.
Agreements can be implied.
Wow.
Expectations can become legally binding.
So like a casual conversation?
The law...
or a handshake deal?
Beyond the surface.
To determine...
the true intentions of the parties.
So you got to be really careful, even with those informal agreements.
It highlights the importance of being mindful of your commitments.
Yeah.
Communicating your expectations.
Okay.
Seeking professional legal advice when in doubt.
Well, that brings us to the end of our deep dive into UK contract law.
Right.
Hope you enjoyed it.
I hope you enjoyed the journey.
Learned something new.
And surfaced with a newfound appreciation for the power and complexity of agreements.
Knowledge is power, right?
Knowledge is power.
You heard it here first.
By understanding these principles we've discussed, you're better equipped to navigate contracts.
Yeah.
Protect your interests.
Make good decisions in your life.
Make informed decisions.
All right. Until next time, happy deep diving, everyone.